I'm Joel Meskin, Vice President of Community Association and Risk Management. One of the questions that we're frequently asked is, what protects voluntary community association board members for the work that they do on behalf of their community association board? Really, the key protection for community association board members is the indemnification included within the governing documents. Having insured as many associations as we have, we've never seen any documents that do not provide indemnifications. There may be a limitation if the board member is allegedly grossly negligent or willful in their conduct. However, the indemnification is what protects and gives the association board members what they need to encourage them to sit on these boards. The key issue, however, is what funds that indemnification obligation. And there are really three things that fund the indemnity obligation. The first one, and the most important one, is directors and officers liability insurance. The key there is that you can create a level of certainty by purchasing a very expansive directors and officers liability policy to fund that indemnification requirement if people challenge the work and the decisions that the board makes. The second, if for some reason the board does not have an expansive D&O policy or something is not covered because not everything is insurable, then you will basically fund that through the association's assets, which are usually obtained through issuing a special assessment. If the association does not have the ability, the assets, or is unable to collect on these assessments, that's when the individual voluntary board member really gets concerned, because then their personal assets would be at stake. And really the only defense there, which they would only be able to establish in court, would be if there's some volunteer immunity. But as indicated, the key is indemnification, a strong D&O policy, and that's how we protect the board members.